knows is the DMV guru. For years, Rick has made it his goal to know any and everything about the DMV. He's had a case, I believe it went to the California Supreme Court called Prince. I believe that dealt with hearsay, if I recall. Rick is up on the latest DMV issues, but not only that, he actually files writs in cases that are appropriate and wins. And in other words, not just handles the DMV hearing issues themselves, but actually goes in, files the writs, sues the DMV, and has won. Tom Conley just told me that he recovered $800 in attorney fees recently after filing the writ with the DMV. So it is possible to recover attorney fees. Rick is going to comment on that. Another issue is sometimes they want us to reconvene at a later date because they're unprepared because they're swamped. And Rick is going to talk about what we should do if we have to reconvene at our expense and at our time without good cause. So Rick is going to be speaking. Cole will be on his way, and when Cole gets here, I'll have Rick introduce Cole. And without any further ado, I'd like to introduce Rick Mueller. Thank you. I see Cole here, so Cole, come on in. I did mention, Cole, that you were going to be moderating. Good to see you. Cole practices downtown. He's associated with the law firm of Lawrence Taylor. Lawrence Taylor does a lot of DUI cases and DMV matters, as everybody knows. In fact, he's written a book on the issue. Cole just won a case down in, I think it was Chula Vista recently, on a GERD issue, the gastrointestinal reflux disease issue and regurgitation. Got it not guilty. I think it was a 1516. Is that right, Cole?
Yeah,
or higher? 1618. So those cases can be won. Cole can comment on anything that Rick is going to be providing. So without any further ado, again, Rick, thanks for coming.
I want to thank Mr. Duquette and the Bar Association for this opportunity. I want to thank Mr. Casey for coming and moderating, and please feel free to jump in anytime. Now, like the Red Sox fan, patience is a virtue, and we are now at an opportunity to outduel the DMV. That's what we're going to do today. We're going to talk about outdueling them. It's a state agency. They're understaffed. They have to review their documents. A lot of you guys win these based on defective documents. What are they doing? Are they reviewing their documents? Are they preparing their cases? You know, the average hearing officer has, 6 cases a day. Sometimes they're preparing, sometimes they're subpoenaing, sometimes they're getting ready to cure their defects. We all get, lucky on some of the easy ones, where the officer doesn't sign off on the DS-367, or where the border agent doesn't show up for the hearing, or the test is more than 3 hours from the time of the driving. But we're going to talk about what we can do to prepare for hearings to win some of the more difficult ones. A week ago, Lawrence Taylor wrote that an article about the injustice of DMV hearings. We all know about it, and I'm not going to reiterate what you already know. We have a DMV employee who's wearing 2 hats, who is not trained in the law, ruling on his or her own objections and sustaining them. Basically, they are hired by the DMV to suspend your license, and you're not really getting a hearing that contains a lot of due process. But what I've provided in the documents today is sort of the parameters of what the rules are and what we can do to exercise our clients' rights on behalf of the respondents. Taylor suggests that 95% of these cases are lost. If that's true, that's scary. It's time that we, jump forward and take some initiative. I lose a lot of cases. I'm losing a lot of cases this year, and I'm fed up with it, and every one of you is too. And that's why you're here. I'm just a person that cares, just like you. That's why we're here, to stop this. And it seems that, you know, they're very much taking the position that if there's a problem with what they did, take it up on a writ. So at the end, you'll see the whole package of the written materials, and for $336.60 or 80 cents, you can file a writ and pay the ex parte motion fee to get the stay. So unfortunately, you know, not a lot of us have clients with a lot of bucks, but in certain cases, that's what we're talking about. And hopefully today, at least, you'll be able to take one gem away that you can put that into a writ, and because they're a lot of fun, especially if you get paid by the DMV. And there's some forms in there on how to request payment towards the end. Those are few and far between. You just want to get your client's license back. And you know, sometimes you come out of these hearings, you say, well, what can I do? I mean, how do I handle these cases? You know, sometimes you think, well, maybe it'd be just easier to get an acquittal on the B section, get a $1 set aside from the DMV legal department, and maybe that's what we need to push for too, as a bar association, to get the DAs to have quick little 10-minute trials on the arrest report minus the chemical test report, and just have them found guilty on the A count and not guilty on the B count, or whatever can be done. But if you don't have the money for a writ, I mean, that's something to consider. Basically, there's three ways of attacking these cases, the way that I think. A, the admissibility of the documents, and also A, the arrest. We don't need to talk much about a warrantless arrest. We all know how to attack probable cause. Fortunately, that's one field where Evidence Code Section 664 of the official duty presumption does not apply. The lawfulness of an arrest is not presumed. So the admissibility part we're going to talk about more today, and that deals with foundation, competency, authentication, hearsay, 13380, the vehicle code, the Mcdonald versus Gutierrez type issues. The second area that I'm going to talk about is the breach of duty. Under the law, if you can show through affirmative evidence or cross-examination of the cop that any official standard, statutory or regulatory, has not been observed in any respect. Okay? You have now rebutted the presumption of reliability and shifted the burden to the DMV to establish the reliability, which means that they're going to have to bring in a toxicologist, much like they did in some of these phlebotomist cases, and try to lay an Adams foundation that the person who administered the test is competent and qualified, that was properly administered, and that the machines are proper working order. Okay? They're not going to do that. Although we did see that happen a little bit when we were attacking the phlebotomist, the unlicensed persons under 23158. Okay? And so every time we do something, DMV reacts, but that's the first time I've seen that. Occasionally, you hear from other places in the state that they will bring in the toxicologist to establish that foundation for the reliability. But once you show any standard in any respect has been violated, the burden shifts to them. Because as it starts out, you have the burden, assuming that they have admissible documents. You have the burden to come forward and show that there's a problem with the foundation, that there's an official duty that has been breached. Now, that can be, the official duty can be anything. It can be Title 17, 1219.3, the failure to continuously observe for 15 minutes. It can be the failure to properly admonish a person. The Nelson versus City of Irvine situation, where the person insists on a breath test and unfortunately they're given a blood test. They have a duty under the statute to give you that type of test that you demand. Any statutory duty, any regulatory duty. With the regulations too, you see some materials in there from the Department of Health Services, where they have approved certain breath test methods and blood test methods for San Diego, for the San Diego Police Department, for the county. And if you can show failure to observe any of those. I've included some very interesting information there in blood test cases. Basically, we know our expert could come in and say that you have to, for example, mix the preservative with the anticoagulant and the sodium fluoride preservative. However, we now have documentation, and it conflicts, by the way, in the materials that I provided. It says that, well, at first they said that you have to vigorously shake it, and now they're saying that you have to gently filter it. But it's got to be done, and now we have it documented, okay? We can't have a DMV hearing officer now saying that I don't find the expert credible. We now have approved methods that we can give the DMV, and that's in the materials. They have to accept those documents. There's plenty of ways to get the DMV documents. If you want to get the DMV some documents, whether it's a declaration of your client under CCP, or whether it's a declaration of your expert, or whether it's a hearsay document, which you can offer, or a document which you want them to take official notice under the government code, or a document that's a scientific or technical matter that they could take official notice of, and there's some examples and documents in the materials on how to do that. Just serve it on them. Serve it on them 10 days in advance, okay? A declaration from your client rather than have your client testifying. If they don't object within 7 days, that document comes into evidence and your client doesn't have to testify, and the statute says it's as if it's live testimony. Live testimony, and they don't get a chance to cross-examine. And you'll see in my materials, the very first thing that I show you on page 3 and page 4 is the government code section, which talks about credibility. And the DMV loves to find your witnesses not credible. Well, they have to make specific findings with regard to the bias, the demeanor, the attitude of your client. Okay? Now, if you can avoid that by serving a declaration 10 days in advance, you've taken them out of their realm right there. I'm getting ahead of myself. The third area that I'm going to talk about in attacking these cases, I think it has to do with time. The time of the driving. The driving must be within 3 hours of the chemical test. The time of the continuous observation must be 15 minutes prior to the person blowing. The date of the blood test record. The blood test record must be made at or near the time of the event under the Downer case, and there's a Downer motion in here in the papers that's going to be an upcoming California drunk driving law book. And you'll see that Downer is still controls. And I had a hearing this week where the blood test record was signed 11 days after the date of the analysis. Okay, so that's not at or near the time of the event as required by 1280B. Now, the particular hearing officer was prepared, so she subpoenaed the criminalist who did come in and can cure that through live testimony. Okay, but so what? At least they're recognizing it. It took years for them to realize that People versus Martinez case, that 2000 case that talked about the rap sheet of the person in prison, the rape, that has nothing to do with DMV hearings. Okay, now we're talking about Downer and Kamuzu. Now, Kamuzu is a little bit of a problem, and I talk about it in my brief. But I did order, and I have attached the blood test record, the actual record. That case basically said that, hey, you know, when the person signed it, that's not when they prepared the report. That was just, they signed it later. They actually prepared it earlier. It was typed earlier, okay? So, but on that document that I've attached to the materials, it says specifically, date typed, date typed. You're not going to get that here in San Diego. They don't put that in there. So in that case is completely distinguishable, okay, if DMV tries to bring that up. Because in that particular case, the document says date typed. And so they made a finding that the writing was made at or near the time of the event. But in your reports, they don't really indicate that. Attacking those records, obviously, you know, the cases like Furman, if the person just puts down that they're a criminalist, yes, they've come around and they've you know, corrected that. They have to show that it's a forensic alcohol supervisor, forensic alcohol analyst, or trainee. Okay, now, forensic alcohol trainee operating under the supervisor's analyst. But if they just show the criminalist down at the bottom of the blood test record, that's not enough under Furman. Obviously, that's objectionable. Now, Don Bartel called me 45 minutes ago and wanted a case that came down out of Westlaw earlier this year. That's where they wrote the criminalist on the test record, but they try to introduce by other evidence the list of persons, you know, authorized to conduct forensic alcohol analysis, and that was the Perry versus DMV. It was not published, but that case said that no, you can't do it that way, and that and they still affirmed the set aside in that particular case. So, attacking the admissibility or the unlawful.
Do you have a side on Perry?
What's that?
Do you have a side on Perry?
The only side I have on it, Richard, and I apologize, it's Westlaw WL 206433. And that's out of volume 23, number 5, page 89 of the drinking driving law letter as well. That's one of the materials you can get the drinking driving law letter from one in Florida, Don Nichols, co-publisher. And that's pretty handy. They get a lot of California cases, published and unpublished, that we don't see. You know, we don't have that watch around anymore to hold our hand and fax us these, you know, while we're sleeping at night. Okay, so we need, you know, you got to get every resource you can to find out what's going on in the cases out there. So those are the three areas: the admissibility and the arrest, the breach of the official duty, and the times and the dates. I think those are the three big areas. Now, starting on page 1 of the materials, that's basically a cheat sheet. That's an outline of the law, carrying the briefcase, whatever. It's hard to read, it's small, you got to get your glasses out. But it does kind of cover the three areas that I talked about. And we're going to cover that in great detail. But moving to the second page. The second page, you may have had the situation where you get into a DMV hearing and the hearing officer says, well, you didn't give me notice of that, you know, 10 days ago. Hello, you don't have to. Okay, this section is very clear. Okay, if they make a request for discovery on you, and they have that little form that they send out to you, a request for discovery, and they mention this section right in there, the 11505. If they make a request on you, you just have to give them your discovery prior to the hearing. That's what subsection B is. So you can tell them before the hearing starts, or give it to them before the hearing starts. Excuse me, I have this, you know. You can show them a copy of this. It's the California Administrative Code of Regulations, Title 13. They have to follow their own rules. This is an example where you use their documents against them. They send out that request for discovery. You look up the section. It didn't take a lot to figure that out. The third page, and this is why I was talking about before about the credibility issue. You know, we all have these problems. Should I put the client on? Should I bring in the expert? Why do they keep saying my expert is saying nothing but speculative things? Why do they keep claiming that my client is not credible? Okay. Well, you can get around some of the credibility problems with your client unless it's the unusual case of being a very good witness, you know, by doing the declaration of the client. But you don't always need the declaration of the client. You don't. Most of these cases that you win, you don't have your client involved at all. Same thing with the expert. You can get the declaration of the expert, and you pay them a little more money if the DMV within 7 days demands the right to cross-examine them, then they have to appear at the hearing. But if DMV tries to give you findings indicating that your client or the expert's not credible, you have to look at this section down here on page 3, 11425.50 right at the bottom. Okay, does the factual basis for the decision include a specific determination based substantially on the credibility of the witness? Do they identify the specific evidence of the observed demeanor, manner, or attitude of the witness? I mean, that kind of limits things. There's always problems with clients and drinking patterns and so forth, and some of that you can cure if there is examination. You know, the officer's rapid firing questions and you told him 2 beers because he never got a chance to tell him about the next place he went to. They're asking another question, you know. Have you been drinking? I thought he meant just now, you know, not much earlier. You can cure some of those things. And then are they going to, in their findings, specifically note something that makes your client uncredible? Because process, you're going to have your client ready, and you're going to think they're going to be credible. As far as your expert witness, I mean, they really don't have much that they can do except try and establish some speculative information out of your expert. And usually you can handle that on redirect. Remember, the burden of proof here is the preponderance of the evidence, okay? And one of the reasons you need an expert here is because we don't know necessarily what particularly went wrong with the machine result. We just know the number's wrong. It's not reliable. So we have to rely on an expert to come in and transcend speculation as to what may have gone wrong and reach the realm of likelihood as to what did go wrong and why it's unreliable, okay? All you have to show is preponderance of the evidence, okay? So a little more than that, okay? So you're going to ask your expert specific questions using the words probably and likely, okay? When you do that, that allows you to meet that burden of proof. Okay, the next hot issue is the Mcdonald case on page 5. It's actually on page 7, but this is my little excerpt that whenever you look at a DS-367, okay? You know, we had the Solovich case, and I included that in pages 8 and 9, and it's important background information. But the Mcdonald case is something that, you know, a hearing officer loves to drool at any little excerpt, any little part of a holding that they can jump on, okay? And then they put it in their little boilerplate. We all like to use our boilerplate documents, okay? And they love to jump on something. But this is an excerpt, the very end of the opinion, that we can really use in our favor, okay? Basically, the law is, on the DS-367, on the officer's statement, okay? Under 13380 of the Vehicle Code, they have to provide, they being the officer, has to provide all information relevant to the enforcement action. Now, the Mcdonald case says, wait a minute, they don't have to provide it all. But what do they have to provide? And can they rely on an unsworn police report? That's the big thing. You don't want that unsworn police report to come in, and then they could point to that evidence and use it against your client. Okay. The Mcdonald case says that if there's something missing in the DS-367 that is material, that affects substantial rights of your client, you cannot omit that in the DS-367. That has to be included in there. If it's not included, you cannot rely on the unsworn report to prove it. And we know that because on page 7 of my materials, it says right at the end of the decision, in light of this legislative intent, the sworn report cannot be wholly devoid of relevant information. However, so long as a sworn report is filed, it is consistent with the relaxed evidentiary standards of an administrative per se hearing that technical omissions of proof can be corrected by an unsworn report filed by the arresting officer. Well, I just so happened to find a case, I think I got it from Ron Jackson actually, I'm not going to take credit for it, that defines technical. And that's the Engelbretson versus Industrial Accident Commission case on page 5. Technical is defined as immaterial, not affecting substantial rights, without substance. So, and if something's in the DS-367, which should be in there. Now here's where your imagination can go crazy. Because the three issues at the hearing are, number 1, was there reasonable cause to believe your client was violating the DUI law? Number 2, was there a lawful arrest? Number 3, was there driving with a 0.08% or more BAC? Now, they have the burden of proof on all 3 of these. So, number 1, usually we give up on issue number 1, but this case allows us a whole new door to attack the reasonable cause issue. And remember that reasonable cause to detain is not reasonable cause to arrest. Okay? The person may have these objective symptoms of intoxication, odor of alcohol, bloodshot eyes, unsteady gait. And that may be enough to investigate. But what does the officer then have to do that is material and affects your substantial rights in your client? They have to perform field sobriety tests. That's what they're trained to do. Where in the DS-367 are the field sobriety tests and the results of that? Where is the reasonable cause to believe that your client is impaired? Is it in the DS-367? Can you base it just on the objective symptoms? I have given you a plethora of examples that the objective symptoms are not enough. The DMV's own manual, which I quote on page 17, lists numerous examples of how the objective symptoms doesn't cut it. It doesn't get you to reasonable cause to believe. The DMV, in their manual and what they've taught their hearing officers, explains that if the person displayed minimal or no objective symptoms, that's insufficient evidence to support the intoxication sub-issue of that very first issue, the required finding that there must be reasonable cause to believe the person is under the influence of alcohol. Now, if you get the second one, the second example, the driver passed out of the field sobriety test, you're lucky, but you're not usually going to get that. And in fact, if you have an expert there, you're going to want to address the issue of whether or not the person's performance on the test is consistent with a person 07 or less or not. And that's because of this Kamuzu case. Now, Baker versus Gorley, the 2002 case that Barry Simons did, says no, you don't have to do that because they can't use circumstantial evidence to prove BAC without a valid test. But if you've got the expert there, you're going to want to use, if they have that information, if it comes in, you're going to want to address that. But back to the DS-367. If it's not in there, it's just a conclusion. It's just objection, conclusion, that the person had reasonable cause to believe, because we all know that bloodshot watery eyes can be from anything, okay? Any Red Sox fan today could be guilty of the officer's opinion of a reasonable cause to believe your DUI. That could be from the night before. That could be because they were tired. Maybe the person didn't even drink. Odor of alcohol, it's not against the law, it's irrelevant. Unsteady gait, that's extremely vague, and slurred speech, which words? Those are just a number of examples. The DS-367, all the relevant information has to be provided if it affects your client's substantial rights. So moving on to, for example, on the lawfulness of the arrest. Now that one in particular, because they don't have the 664 official duty presumption, they have to be very specific. And I've included a number of documents from DMV where they give examples of what's good and what's not good PC. Those examples are on page 13. Okay, what's insufficient? Okay, right at the top. Probable cause statement is blank or see attached arrest. I think they mean attached arrest report. Okay, that's insufficient. This is the DMV's own people who have looked at this. The officer